Tumawag sa inyong kumpanya ng telepono para magpalista o sa 1-866-272-0353 para sa impormasyon.
Kababayan LA, earlier pinag-usapan po natin, they say that pagka pinetition kayo at yung petitioner nyo ay namatay, unfortunately mapapawalang visa yung petition sa inyo. But not anymore. According to Attorney Richard Lo, makakausap po natin siya sa ating American Dream.
This American Dream segment is brought to you by Aquino & Lo Law Firm, answering your immigration questions.
Attorney Richard Lo, a second time on Kababayan LA, first time in this segment. Hello and welcome back on the show.
Hello, good to be here.
All right, Richard, let us talk about this new law. It's called Surviving Relative Law. It was enacted October 2009, and basically, what does it say?
Basically, what it does is it allows people whose relative died while petitioning for them to continue on with the petition. Before, we were only able to continue on with the petitions that were filed by spouses for their spouses if they were married for 2 years. But now, a spouse or a parent or a brother who passes away, that petition can still go forward.
And this is a big problem for the Filipinos because, as we know, a lot of petitions about concerning relatives, it takes a long time, and sometimes before that petition, their priority date becomes current, the petitioner dies. So now, and then they say that the petition dies with the petitioner. Now it's not necessarily that case anymore, right?
Right, that's precisely right. It's not necessarily that case anymore, and this is particularly helpful with these long waiting periods we have for example, brother or sister petitions or parents for petitioning for their married children.
Okay.
And before, we weren't even able to, once the petitioner passed away, if the petition hadn't been approved, then we had no recourse. There was nothing left that we can do but circumstances.
Okay, and what are those circumstances? What are the requirements for this surviving relative law?
Well, for the surviving relative law to apply, the beneficiary has to be here in the United States when the petitioner dies, and the beneficiary has to still be in the United States now. So this will affect a lot of people who have been in the United States waiting for their petitions by their loved ones to be approved or for the priority to be current, but unfortunately the petitioner has passed away.
Okay. What about, say, for example, I'm a daughter, my mom petitioned me, and something happened to her, but I still have a dad or I have a brother that can still furnish an affidavit of support?
Yeah, that's right. As long as you have a person that can step into the petitioner's shoes, and that's generally a parent or a sibling, it could even be in-laws, like a sister-in-law or brother-in-law, then you can continue on with the petition, even though the person who was going to sign the affidavit of support has passed away. And another, remember, for people who have been here a long time and have been working in the United States and have already qualified for Social Security benefits, you don't have an affidavit of support requirement, so you can continue on with the petition, even if you don't have a sponsor who can step into the petitioner's shoes.
Is there a time limit, though, that you mentioned earlier? If you have been working here, you can continue on your own petition. Do you have to be working for, 10 years? You don't need an affidavit of support?
That's right. You need 40 quarters to be qualified. And generally speaking, those people who have received letters from the Social Security Administration saying that they are now qualified for benefits, that's the easiest way to tell if you've received 40 quarters of work. Most people will have to have had a valid Social Security number in which they're working under in order to be qualified to get the affidavit of support waiver, but there are many people here who are working who do have that ability.
Okay, and just to emphasize, I know you mentioned this earlier, this is not just limited to spousal petitions, right? All kinds of family petitions.
That's right. It's not just spousal petitions. It's petitions filed by anybody, including parents for their adult children, brothers and sisters, and it also applies to derivative beneficiaries. That is, people who may have been spouses or children of a beneficiary who passed away, and also employment-based. In some cases, this can also continue on with those petitions.
Okay, well, this sends now a clear message to our kababayans because some of us are discouraged because we pay such high filing fees for petition, and then we're discouraged because, you know, it takes a long time. So it's still advisable to file that petition?
I think it's always advisable when there's an opportunity for somebody to file a petition for you. I think you should have that petition filed. We never know what's going to happen 10, 15 years down the road. I see so many clients who's come into my office and their sibling was a U.S. citizen for the last 20 years, but they didn't have a petition filed, and they just didn't think it would ever come to this point.
Right.
It's so important just to get the petition filed and put that out there so that someday you might be able to use that.
Thank you so much, and more power to you, Attorney Richard Lowe of Aquino and Lowe Law Office.
Thank you.
They do give free consultation. We were flashing the number earlier, pero yung free consultation po, pang office consultation lang. And we will be back on the show. This time, let's talk to a kababayan achiever. Don't go away.
Imagine relaxing to the world's most